on our website. Will be on our website, so that you could come back and watch it again or tell some friends about it. So without further ado, Attorney Bernard Kennedy.
Thank you, Nikki. I appreciate that, and couldn't have said it better myself. Um, I love working with creatives, whether that's musicians, writers, artists, film writers, whatever the case is. It's just a big passion of mine. And like you said, it started in music before, and it probably started as a young kid when I was watching my grandfather make paintings himself, a lot of them oil paintings of local scenery, and then it's just kind of spawned from there. So I am going to share the PowerPoint presentation with you guys, and we'll just walk through it. And like Nikki said, this is based off of the questions that were submitted to me. And if there's additional questions, I think Nikki will be able to take those throughout and chime in here and there. And then if we don't get to them, save them for the end. We're happy to answer them at the end of that. And then if we still don't get to your questions, you guys can feel free to reach out to me. I'm happy to, I love talking about this stuff. So I'd be happy to connect with you individually. Okay, so let me share my screen here. Start the slideshow. Okay, so the first question that was given to me, which I think creates a nice base for all of the remainder of the questions as well, was who receives credit when a painting is based on a photograph? Particularly when there's another photographer that's involved that's created the picture first. As you can see here on the right, I've included a picture. This picture itself actually comes from unsplash.com, and that's a royalty-free service that has a licensing agreement that allows users to use photos without infringing on copyrights. We've also included a couple additional resources below. What you'll want to know about each of those is just make sure that you're looking at the licensing provisions to make sure that you are allowed to use those as paintings. To go back to the question though, the person who took the photograph is the original copyright holder of that photograph. So if an artist was to use that photograph and make an exact reproduction of that photograph, that would technically be infringing upon that photographer's photograph. So what you would need there is that artist's permission, or the photographer's permission, to be able to use that artist. And that actually leads into the next question that I received, which was, if a photographer verbally grants permission to use a photograph, is that legally binding? And as you can see here, we have somebody that's giving verbal permission to somebody else. And while that is technically inadvisable, or technically that is correct, I would like to kind of step back from that a little bit to say that if it's going to be legally binding, it's something that you want in writing. I'm going to tell you why. So say you have a photographer, his name is Joe. You ask Joe if you could use his photograph to make a painting. You take that painting, you make it, you sell it for a substantial profit afterwards, and then Joe comes to you and says, I didn't give you permission to do that. Well, you're going to find yourself in a position there because it's going to result in a long, lengthy court battle that's going to be costly over a period of time because it's hard to prove what somebody has said verbally. So always try to get it into writing if you can. That way, Joe can't later come back to you and say, I didn't give you permission, when you have his certain signature right there in the piece of paperwork. The question is, what type of agreement are you looking for in that instance? And that is a licensing agreement. So a licensing agreement is an agreement that allows a third party to have specific rights to use artists' intellectual property. So you're going to name exactly what that property is, And within that agreement itself, you can talk about the length of how long you have the license to use that. If you're going to be selling the painting based off the photograph, what are the royalties that the photographer is going to be seeking? Do you have the ability to sub-license that picture? So somebody makes a picture based off of your picture. And is this going to be exclusive? Does the photographer have the right to tell another artist that he can use that painting? So what you want is as much information as possible in writing that covers all of these potential terms, because you want to be able to go back to it later in the event that you see another artist that comes out with the same painting as you based off that photograph. Or the photographer, like we said, tries to say that he didn't give you permission to do so. The next question that I received was, can a commission client refuse a painting if they don't like it? I like this question a lot because it brings up a good, important question. Where I think of an artist that paints animals for a living. And somebody comes to you and they say, I have the most perfect dog in the world. Can you please reflect my perfect dog within a painting? That's a really high bar to meet, because in everybody's mind, they have the best looking animal on the planet, right? So it's hard to make sure that that person is going to love every second of it. And again, what you want to do in this instance is make sure that you have a contract put in place that states things like how often, how inclusive of the individual that's commissioning you, how are they going to be included within the revision process over a period of time? Do they get 1 or 2 revisions? Are they supplying you with a photo that you're supposed to adhere to exactly? What does it say regarding being able to reject your painting and come back with another painting? Or are you just going to have a fee that's paid half up front, half at the end, depending on whether or not they like it? There's a lot of different ways that you can address the commission piece, but again, always in writing, because what you don't want to do is spend a lot of time working on a painting and then you present it to somebody up front and they say, oh, I don't like that at all, and you've just wasted a lot of your time, right? So again, always in writing, and you're going to see that that's probably a reoccurring theme throughout this, but I feel that I have to really harp on that because most of the problems that I encounter, especially relating to artists, are after the fact, when they probably could have had something in writing up front that would have helped them later on down the line. The next question, how can you legally make reproductions? Here, I'm thinking of a painting that does very well, and you want to come out with lithographs of that painting or something to that effect, right? And on the bottom of the painting, you see 1 out of 100, 1 out of 50, whatever the case may be. And you also are very successful in selling that first batch of 50 paintings or reproductions. And now you want to go back and create a second batch, right? One method here is to sign, date, and number each piece of the artwork. That could either be on the front of the painting or the back of the painting, and that also applies to the reprints. And another method would be coming up with a certificate of authenticity for each painting. Where you will run into some issues with this is if you are trying to create multiple batches of work, the problem being the valuation of that 1 through 50 originally may be secured for you. And as you start introducing more reprints, that may drive the valuation of your original prints down. So you have to be very clear that your next batches are new batches, right? That way the original owners can maintain the value of the original batches, okay? So next, what would be involved if an art gallery wants to print an image, make cards from an artist's work, or make limited edition prints? In this instance, I think of postcards, right? You go to a local gallery and then they have a postcard of one of the paintings that's in the gallery, and who gives the right to be able to do so. Again, thinking back to the licensing agreement that we spoke about before, you want to make sure that there's a licensing agreement in place, or if there's an exhibition agreement in place, it also accounts for the licensing component of your artwork. Because the artist is the holder of the copyright, they are going to be the ones that dictate the terms as to whether a gallery can print an image. And what you would like to see in this sort of agreement is you would like to see the artist have the ability to say what can be reprinted and what cannot be reprinted, and have final say as to any of those reproductions. I'm going to use a mural as an example. There are several people that have created wonderful murals, and then the building owners either want to sell t-shirts or coffee mugs or a number of different items that they can put those paintings on. The artist may not want their paintings on a coffee mug. They may feel that that detracts from the value of it. So you want that right to be able to say, I only want postcards, and that's it. And then within that, who gets a part of the commission, or what's the commission split? For every postcard sold, is the exhibition or gallery entitled to 50%, 60%? It's usually somewhere around the 50% time frame from what I've seen, but it's very helpful to have all of this addressed in writing up front. Okay. This question, I enjoy this question a lot, because a lot of people will go online to find all sorts of agreements that they can use for themselves. It's cheaper, certainly, than going to an attorney. But what I would like to say is, please consult an attorney, even if it's just you coming up with an agreement in place that is going to be boilerplate moving forward. I wouldn't trust what you're going to find online, because you don't know who drafted that, and you don't know if they have the requisite skills to be able to account for anything that you may potentially come across. So even if you find an agreement that you like a lot and you want to use this agreement moving forward, please just bring that to an attorney to say, am I thinking of everything? Is there a force majeure clause in there, which essentially states that you couldn't complete the work due to an act of God? Is there certain other provisions that you have to be aware of that you want to make sure that you're fully protected? It doesn't account for it in the agreement that you found in Google. It's just very helpful to at least seek a little bit of advice as to how to proceed here. Okay. This is a huge topic now as we go into the digital world. How does an artist protect art on their website from being stolen, essentially? There's a lot of different ways that you can do that. The first of which is just adding a watermark to your image, that if someone wants to purchase that image from you afterwards, you're happy to remove the watermark to them and send it out to them. But for the time being, while it's up on the website, you're going to want your watermark on that image. Some people don't like that because they think that it detracts from the
same thing. All these places, there's been all this upheaval. We thought there'd be a really cool.
Hang on. Hello.
Yeah, I got you.
Let's make sure we're muted. We have a conversation going on in the background. Okay.
Right. We're good.
Thank you, everybody.
So there's another way that you can go about it, which is to disabling the right click on the ability for someone to take a right click over an image and save that to your computer. There's ways to disable that. One that I try to point people in the direction of, I know a lot of photographers that use this as well. This is SmugMug, right? SmugMug is the example of a website or a service that will actually encrypt your photographs that are online to make sure that those can't be reproduced. SmugMug is good because they alert you if they think that someone is trying to steal your copyright. And then also, if someone does download that image and then, for example, takes it up the street to CVS to have it printed, what prints out actually is that this product is copyrighted. You don't get a picture itself. So it's one way to try to combat it. That's just, I think you take this into pieces along with everything else to add maximum protection. So maybe Watermark and also using SmugMug, or there's other different online monitoring services as well. Some people upload low resolution images, and then similar to the Watermark, they can make high quality versions if it's going to be something that is available for print for purchase. And then finally, register your copyright with the Copyright Office. Fun fact that I think everyone should know, we're going to get a little bit more into this, but if you take your photograph and you actually post it onto Instagram, you're giving Instagram a non-exclusive license to use your copyright moving forward, which is something that you wouldn't know unless you went into the terms and conditions and then into the licensing section. And that has to do with all those little boxes that you check before you actually sign up for Instagram. So that's just one potential issue that you may encounter with social media. If work is displayed in a public place, how should artists protect themselves from theft? I thought of this in two different ways. The first way, is obviously somebody just walks up and takes your art and walks out of the gallery with it. And what do you do in that instance? Someone has stolen your asset. So the first thing that you're going to do is call the police. If someone steals your intellectual property, it looks a little bit different. As you can see in this picture in the top right, there is somebody in the background taking a picture of their phone of the photo that's hanging on the wall. That person then takes that picture that's on their phone, they go home, they crop it, they reproduce it, they sell it themselves on a t-shirt, right? What do you do in that instance? Well, what you're going to do is have a copyright infringement letter sent out on your behalf, or you're going to send it out yourself. And if you don't get any response from that, say there's no takedown from there, you're going to want to contact an attorney to send out either a demand letter or start a civil suit, but it usually starts with a demand letter before going into the civil suit, essentially stating that somebody has infringed on your copyright and has profited off of it as well. And then how much responsibility should be on the gallery in the case of a theft like that being occurring? So again, if you think of the woman who's taking the picture in the top right here, in that instance, what does the contract say about, is the gallery responsible for making sure that no one comes in with a phone to take pictures of the art that's in there? You're always going to want to make sure that that's something that is clearly written into the agreement as to who is liable in the event that the intellectual property is taken. Maybe it's both parties agree to contribute to defend the copyright if something's taken in that instance, or maybe it's just going to fall down to the gallery themselves. And then what you're looking for from there is, was the gallery acting negligent or reckless with regards to your intellectual property? So there's going to be a path for you, but you have to be diligent in your protection of your copyright. Okay. Next, how does an artist assess the value for insurance purposes? This was a great question, not a legal question. So what I did was I actually reached out to an insurance agent friend of mine to see how they typically will walk through this artist piece for you. And insurance companies value art similarly to the way that they would jewelry. So if a jeweler creates a piece, they have an appraisal performed by a third party, and then they can take that appraisal to the insurance company, and the insurance company will insure the value up until the appraisal amount. Unfortunately, that may not always equate to what you think the value of your artwork is, because tangible value and sentimental value are two different things. However, if you're going to look for somebody, and I did a brief search in Connecticut to see who offers this, and there does seem to be a few companies out there that I'm not going to endorse here, but what I would say is look for somebody that is certified and it operates under the United Standard for Professional Appraisals Practice, right? To make sure that you're getting certified appraisal of your artwork. Other things that I've seen relating to this, people tend to value it based on hours spent versus what they want to be, what they want to receive hourly, and then any additional amounts that they've actually spent on things like canvas or paint. you know, there is a way to monetize it yourself, but highly recommended to go get an official appraisal done if you're going to get insurance on the piece. Going back to what we were talking about before, should you watermark your artwork on your website or your social media to protect it? This is one way to go. However, there are services that like SmugMug that can help you to protect your images online for a fee. It's a yearly fee, but it's probably a much lower fee than what would actually account for you having to start a legal action. I'm going to give you one example. I have a client, another insurance agent, who he posted a picture on his website. It was July 4th, and it was just a celebratory website. A week later, he got an email from an attorney from California, and within that email, the attorney demanded $5,000 because he had violated somebody else's copyright, or he had infringed on somebody else's copyright by not seeking permission before he posted that picture to his website. The insurance agent paid out this $5,000 because it was probably likely that he had a very strong case. He didn't have any permission to be able to post that. And the reason that that photographer figured it out was because he was using an online service that helped to monitor. So not only was he able to ferret out that somebody infringed on his copyright, but he also helped pay for the service that he was currently using to have protection of that photo. So another great question, which brings us to where we're at currently digitally, right, is can someone grab it anyway, make an NFT out of it? NFTs, which I'll go a little bit more to in just a second, but suffice it to say, anyone can make an NFT out of any image, not even any image. They can make an NFT out of any song, right? And you're probably wondering to yourself, well, what does all of this NFT mean? It's a fairly recent creation within the past 2 years. So I will jump into that, but just know that just because somebody makes an NFT doesn't mean that they've obtained a new copyright over what they've made. Okay, NFT stands for non-fungible token. And essentially, it's a unique image that can't be replaced because there is some back-end computer coding, which is way beyond my scope, but there's a way to make sure that there's like a chain of title. You think of it almost like a deed, right? There's a very unique deed within NFTs. There's very unique coding. You can trace the ownership of who owned that particular coding, and that's kind of how they secure their rights to a particular NFT. And this is actually purchased through Ethereum, which is a form of cryptocurrency. When you think of cryptocurrency, you think of Bitcoin, so you can see kind of how complicated this NFT process is, and a lot of it is really new law. Because this didn't exist recently. So people are trying to figure out exactly how does intellectual property, contract, taxes, everything else apply to this new item called NFT. I put this picture in the top right here of the cow because you could literally take this cow picture and make an NFT out of it. Whether that's going to be something that's valuable that somebody wants to purchase is another question. And I think that kind of goes back to what we were just talking about with watermarks as well, because someone could take your watermark picture, absolutely, and they can make an NFT out of it, absolutely. Is that worth anything? Is anybody ever going to attempt to buy that? That's the piece where you're probably not looking at somebody profiting off of your watermarked image, okay? So I included a link here, OpenSea.io. If you guys are ever curious, just go to OpenSea.io, and that'll explain a lot about NFTs to you. That's actually the NFT marketplace, and you can actually create an NFT right on that website and list it. That's how easy it is to get out there. So again, just creating chain of title for NFTs, but is it really worth it anyways? And this is another great question because this will speak to the business of artists a lot, which is if the cost of my work outweighs my profit, should I not report the sale to the IRS? And what I wanted to do was include a definition from the IRS as to what a hobby is for you, so you can kind of see what the difference is between somebody who's merely just creating paintings or somebody who's trying to create a business out of it. So a hobby is an activity that a person pursues because they enjoy it with no intention of making a profit. I think the key term there is no intention of making a profit. However, generally speaking, all assets sold have tax implications. So this is my PSA to say, have a great accountant in place that can help you with this. I receive calls every single day about people starting new businesses, whether that's a creative, whether that's an electrician. And I could be the first call or I could be the second call. It doesn't matter the order there, as long as one of the calls is an attorney, one of the calls is an accountant. And typically we work together to make sure that you're selecting the right entity moving forward if you are looking to start something like an LLC. However, do not proceed without at least speaking to an accountant as well, because they will tell you very clearly what needs to be listed for the IRS and whether or not you may be able to use some of those deductions based off of losses if you haven't been able to recoup the profit that you've put into your painting, right? So PSA, please call an accountant as well. I shouldn't be the only person on the list. It should be a team effort to make sure that you have maximum protection moving forward. And if an artist copies a portion of another artist's painting into their own painting and then sells that painting privately without marketing it on their website or social media, does that constitute a violation of copyright law? If you see me looking to the side, I have the same slides over here. It's just the video cuts off some of the words. So I look to the side for a moment. Good question. There's multiple parts to this question. Anytime someone reproduces anyone else's copyright, that is considered infringement, whether that's going to be sold publicly on the market or privately in your own home. It's always going to be considered infringement there. Whether you can use a small portion of the art depends on whether a court would consider that portion to be transformative, because there are exceptions to copyright infringement called fair use. So the question as to whether you can use a portion of somebody else's art kind of depends on a four-part test that's supplied by the court system. The leading case on it is actually revolving around a rap group from the late 80s, early 90s. They were called Two Live Crew, and they sampled a portion of Pretty Woman. The copyright holder of Pretty Woman did not want Two Live Crew to sample the song, so they sued them in court, and the court ultimately found that the song was a parody. And because of that, it did not infringe on that person's copyright. And I think another great example of that would be Weird Al Yankovic, who makes a lot of songs based off of making fun of other people's songs, right? Those are parody songs. You're not infringing on somebody's copyright in that instance. But I included a converse of that as well, which there was a photographer who took several pictures of the artist Prince. Andy Warhol wanted to make silk screens and pencil drawings based off those photographs. And in this instance, the photographer gave Andy Warhol the license to use one of the photographs, not all of the photographs. And what the court did was hold that Warhol's images retained the essential elements of the photograph, meaning that there wasn't much changed within the photo at all. And without significantly adding to or altering those elements, it was not transformative. So my advice to you would be, if you're using somebody else's copyright and it seems similar, you may want to, before monetizing or copywriting yourself, registering your copyright, you may want to speak with an attorney that can walk through the 4-point test with you to see if they believe that it is also far enough removed that it's now transformative instead of just copying somebody else's work.
Excuse me, Bernie.
Sure.
We have a request. Can you elaborate on the word transformative?
Yeah, absolutely. So transformative, I guess what I should have done was include the 4-point test for you, but transformative has to be so far removed. You can't look at one picture and say, oh, it's not confusingly similar. Let's put it that way. You don't look at one picture and say, oh, that's based off of the photograph that was taken with prints, right? That would be a great example. It almost seems like it's an entirely new drawing. So while maybe you've conceptually taken some parts of somebody else's painting and you use I'm thinking of use manta rays instead of sea turtles in painting or something to that effect. You've transformed that painting at that point in time. So another good example would be collages, because I think that you probably see a lot of this pop up in collages. And if you're placing a ton of different copyrights all together to make something completely new, that may be considered transformative as long as it's very far removed from the original painting or picture. Okay. Is there other questions as well?
There is. What about, Victoria said, what about Sophie Matisse's Out to Lunch series?
I don't know Sophie Tease's Out to Lunch series. I apologize. That's something I'll have to look into after this for sure. So if you want to send me an email afterwards, I'd be happy to look into it for you and we could have a further discussion about that for sure.
Okay, and then for everyone else out there, if you have a question, simply put it in the chat and then I'll be able to ask it. And now we're starting to get more questions.
All right.
But you could continue and then I'll interrupt when it's time for questions.
Sure, wonderful. Do each of the paintings on my website need to be copyrighted, or can a copyright be written so that everything on that website is covered? Perfect opportunity for me to say that you have a copyright as soon as you put the artwork into tangible form, right? So it's not that you need to register your copyright to have it. You technically already do have it as soon as the painting becomes is into existence. However, when you register your copyright, you get added additional protections. So that means if you register with copyright.gov, the registration is necessary because it allows you to recoup attorney's fees in case you have to litigate to protect your copyright, and it also allows you additional monetary damages. All of your copyrights are going to be done through copyright.gov. There's no other way to establish that copyright, at least register it. And depending on the type of the copyright registration, it can be anywhere between $45 and $500 for a single author, one piece of work, not made for hire. That is going to be $45 through the copyright website. If you want to file compilations, so multiple works at the same time, there is a pay scale that's included there. But for the purpose of this question, you can absolutely make more copyrights than just one at one time. Okay, so that really, it's a sliding scale in terms of how much it's going to cost.
Here's another question for you.
Sure.
Do we need a formal release from a paid portrait model in a classroom environment in order to use his or her image in the artist's social media?
What I would do is make sure that the school had, if you're going through a school in that instance, I would make sure that the school had a release. I assume that they would, and in prior instances, I've seen a lot of a lot of models have to sign releases before they can subject themselves to the class, right? So, and if not, and they don't have that, I would inquire as to, can we put a release in place, especially if you plan to monetize based off of the drawing or picture, okay? So it's kind of an additional inquiry that you have to ask for your school. Sometimes that stuff is blanket covered. I know when I was in college, I had to sign something that said it was okay anytime my picture wound up in, you know, the local newsletter that was produced by the school, essentially is signing my name and likeness over, so there is no issue if they want to reproduce a picture later on. Okay. Next question, if an artist sees something in a painting that inspires him, can he use that idea in their own work? And I like this question a lot because it allows me to kind of fill you in on that. Ideas are not something that you can copyright. Thinking back to that you already have a copyright, as soon as something is in tangible form, it's not a copyright when it's here. If I'm writing a script, it's a copyright as soon as I start writing it on a page, not while I'm talking about it out loud with just my thought process though. So I thought I would include a couple examples that might be able to illustrate this for you a little bit better. The first one, a little broad, but at some point someone created reggae music. It's not that they can prevent others from creating reggae songs. It's more that they can't prevent another person from coming out with the same exact reggae song, with the same melodies and the same words, essentially. Example 2, I have a client, he likes to write thrasher films. He asked if he could protect the idea behind his murderous plots. And while he could protect specific details like the names, the jobs, the locations, and the gritty details of the story behind it all, what he could not protect in that instance would be the idea of a disgruntled old individual going on a killing spree for revenge. If he was able to do that effectively, there would be no additional thriller plots. You would only have that one movie, and then that would be the end of thrillers, right? So example 3, just to try to bring it home a little bit, you go to Hammonasset, you see somebody standing in the back end of the cliff in the back there, taking pictures over the bay, or maybe creating a painting based off of the same bay, and that inspires you to create your own painting from the same spot. The original artist can't prevent you from doing so, as your painting will likely be very different. I was talking to Nikki recently, actually, and she had commented, it's so funny how everyone could be staring at the same thing and come out with 10 different paintings, right? So I think that really ties into using ideas as inspiration, which we should be able to do, because if not, you know, art is kind of born from art, right? You have to find your inspiration from somewhere. Okay. Going back a little bit again, I've always thought that getting a copyright is an expensive and long process. Is there a fast and inexpensive way to copyright my work? You already have your copyright, as we just learned. You technically already have it. The reason that you register it is for those additional protections. It's not that expensive of a process. The attorney that you use may be expensive, but if you're doing it yourself, you know, it's $45 for that one work like we just spoke about. The application process takes 3 to 9 months to receive those additional protections, but you still have the exclusive right called a bundle of rights, as long as you've created the tangible piece of work. So that bundle of rights includes the ability to reproduce the work, to prepare copies of the works, to distribute copies of those works for sale. Say you've created a play or a musical, the right to perform that work publicly, or display the work publicly, specifically thinking of galleries in that instance, and the right to license out any of the above rights, right? So you already have all of those things. What you're just making sure in this instance is that you get those added extra protections from registering your copyright. So it can be a fast, it's free to create the artwork. It costs money to register for the additional protections, and somewhere between 3 to 9 months. If my work is copyright protected and I see that someone has copied one of my paintings, how do I go about challenging the other artist? The first thing that you do is you send a notice of copyright infringement, request for removal of infringing material. This is a form that is found right at copyright.gov. However, just thinking back to that example where the insurance agent that I know infringed on somebody's picture, he received a demand letter for $5,000. It may be useful to go out to an attorney to have them write up a demand letter for you in this instance to try to resolve the matter and potentially recoup you some funds in the process. If you don't hear anything back, the next step for you to do is to file a civil claim for copyright infringement. And for that, it's a very complex area of law. So I would highly advise having an attorney for you in that instance, just to make sure that they can walk you through not only the procedures, but the intricacies of copyright infringement. And that brings us into photography, which is almost its own beast here. Because what I get this question a lot too. It's what happens if I take a picture of somebody in public, their name and likeness is protected, and violating that. And what it comes down to is state laws. In Connecticut, there's a voyeurism law that prohibits knowingly photographing, filming, or recording in any way another person's image without consent, where the person is unaware of the filming, not in plain view, and has keywords, a reasonable expectation of privacy. Most of the court cases that are brought, the big question is, what is a reasonable expectation of privacy here? If you are walking, keep using Hammonasset because it's a wonderful place. If you're walking up the street at Hammonasset and someone takes a picture of you in a state park, can they reproduce that picture? According to the voyeurism law, they can, because there's probably not a reasonable expectation of privacy while you're walking around in public, but you still see people sue over this stuff anyways. There's a really good example of an individual out of New York City. He created an Instagram account called Humans of New York, and he has a lot of different legal issues going on because of it, because what he would do is walk up to individuals and take a picture of them. And then he would post it on his Instagram account, which I guess you're assigning Instagram the right to use that in the meantime. And then later he wanted to create a book to sell of those pictures that he had. And he got several complaints because he didn't get a release from everybody in that instance. So if you think that you're going to be monetizing the pictures that you are taking, it's highly suggested that you get a release put into place. And that release is asking for that person to release their name and image and likeness to you so you can then profit off of it later. Okay. And those are another thing that you might be able to find online, but you could also have an attorney draft you up a very well written, tightly aired release agreement for you to use moving forward. It's always going to be a question. And just going back to that Humans in New York, he's also involved in several litigations now because there's Humans of Dubai, Humans of London, and he's trying to protect that brand essentially in that instance. So we'll see how those come out. A lot of that is still ongoing, but a lot of different intellectual property lawsuits going on because of that. So then the last question that I received was, what is the difference between something being illegal and something being unethical? And I think that this is a fantastic question because illegal is not just a crime, not something that's going to end you up in jail. It's a civil claim where you violated someone's statute, like the Copyright Act, right? When you infringe on somebody else's painting, at that point, that's illegal. Unethical, what I think of in this instance would be there was an R&B singer, his name was T-Pain. He came out in about 2008, and he started using what was called auto-tune. And auto-tune allowed singers to, terrible singers, to hit the notes perfectly. It automatically adjusted their voice just so they could be the best singer on the planet. And a lot of people in the industry thought that that was highly unethical. Since then, if you turn on the radio, chances are you're hearing somebody use auto-tune, but at the time it was considered to be very unethical. So the way that I think of it is, what does your community think of what you're trying to accomplish here? And is that unethical within your respective community, versus did you violate somebody else's rights, in which that instance you would be thinking about, is that illegal? And that's really it for this piece. It can go, the law of art is so interesting. It touches a lot of different areas of law, whether that's going to be estate planning, how to pass along your paintings to your children, whether that's going to be contract law, as you see, because there's a lot of different types of contracts that you want a professional to look at for you. And the only thing that I could relate there is, a lot of people, you shouldn't be fixing your own brake lines. You want a licensed mechanic to fix your own brake lines, right? Otherwise, something very bad can happen. And I think of contracts in the same way, which is, you don't want something very bad to happen. So you should have a professional look at it. And then there's also intellectual property, which is at the forefront of all of this. If you guys take away anything from this, just know that you automatically have the copyright, and registering those copyrights is what allows you to have additional protections to what you have. And that's really it. You know, I really enjoy this stuff. So if any of you ever want to reach out, I'm just happy to talk about it.
Bernie, thank you so much. We do have a few more questions,
right.
and it was very informative. I learned a lot from your presentation. So the first question, I think we might need more information. It says, what about using strips of pieces of printed paper in a collage? Do you have to create your own paper? I think it depends on what's printed on the pieces of paper, correct? If there's image.
So it is, there's actually a very, if you can grab the individual's email address, there's a very specific legal provision relating to what collages are in terms of copyright. And I'd be happy to supply that. If it's transformative, I believe is going to be the answer that you're looking for. If there's a lot of different people who have used collages throughout time to create wonderful art pieces. The individual who created the underlying piece still technically owns their copyright over that piece individually. But if you're going to put it all together and it's transformative in a way that it's so far removed from the original painting, you should be okay.
Okay. Next question. If you have a specific style of creating a character, would each iteration of a character need a copyright? And in parentheses, think Keith Haring.
Each individual ideation of a character, do they need a copyright? That is a great question. It would depend on, well, I guess there's two things there. Would you be looking to potentially trademark the character as well? Is it going to be something that's used in everyday marketing? The second piece of that, though, if the character itself as written should receive one copyright. If it's going to be completely different, I think of I'm just trying to think of a good example here. I'm thinking of like different ideations of Batman over time, right? The drawing. Each individual one would need its own copyright, but there would also probably be something filed underneath all of it to protect the character generally. Okay.
Okay, that makes sense. Getting some great questions. I like the idea of the next one. Can you use QR codes to connect to poems available on the internet? This would be for the purpose of creating a poetry trail in the woods. Why not?
Yes, so are they your poems that you're directing them to, I guess would be my follow-up question to that. But I don't see why not. That's actually, I would love to be walking through the woods.
No, they wouldn't be your poems. They would be poems of famous poets.
Sure, and when you're
mean-
directing that to those famous poets, is that back to a website that's operated by you?
No, to a like a foundational website, like Poetry Foundation. I understand they're very protective of copyrights of poems being reproduced, but I
Right.
wondered if QR codes was something, you know, that the poem isn't being reproduced, it's not pictured,
Right.
just
I think
audio.
we're okay with that because I almost think of it as like a website.
Yes, yeah.
Right. So if you're just going to write somebody's website out in public somewhere, does that violate the copyright that they then have on that website? And I don't think that it does. And you're not really reproducing their work at all. You're just giving an avenue to say, hey, you should go here. You haven't established, yeah, you haven't reproduced their artwork at all in that instance, so you should be okay.
What a great idea. So,
Thank you. Thank you so much.
another question, can you use images in a PowerPoint for the purpose of education? Do you need to cite the images?
Yes, all the images that I used in this actually came from free, royalty-free websites, which I very specifically always try to do so I wouldn't have to. But we talked a little bit about fair use before, and one of those exceptions to fair use is educational purposes, which we didn't touch on today. But you think of teachers in a classroom for a minute, they reproduce a lot of different things that have copyrights over time, whether that's going to be a Robert Frost poem or a picture of the Mona Lisa. You see it a lot in class. So as long as it's used for educational purposes, you qualify under the fair use exception.
Okay, next question. Should you remove your paintings from social media?
If you don't want them to have a non-exclusive license to be able to reproduce it themselves. While highly unlikely, technically, if Facebook wanted to put up a billboard of a picture that you put up there yesterday, they can do that while it's on there. What some people do is try to build a following up with what they're posting on the website, and then once they've achieved a certain point in time, everything just gets directed back to their individual websites. I have a friend who's a photographer. The only photos that he releases is through one of those protected websites that we were just discussing before. What is it? Give me 1 second. So SmugMug. That's it. Sorry, I was slipping my mind. So this person just lists it on SmugMug. SmugMug doesn't have a royalty-free license or anything. They actually help protect it for you. So if you don't want Facebook or Twitter, and you're gonna have to look at Twitter's individual licensing agreement. I don't know that one, but if Facebook, for example, if they lose that right as soon as you take it away from them. It's not like they have it for all of time.
But what about, I've seen a lot of artists on social media have that watermark where it will say copyright and then let's say the name of their name or the name of their studio. Is that another way to get around that?
It's not getting around it because they still have the exclusive use to use that photo, even if it says copyright on it. it'll say copyright on it. So what you're doing is deterring people from using that image because it has a watermark out front, and somebody presumably wants the clean image, right?
Mhm.
So it's one way to deter, but technically you've just given the license to Facebook to use the image with the watermark on it.
Okay. Next question. Most art organizations prohibit the artist from using any other photographer's photo for art. That photographer created the composition and color harmony and strength. So I think that's a statement. Okay. Next question. In a painting workshop, when pictures are taken of participants, do we need their permission to use their image for social media and advertising? I know that I've been in plenty of painting workshops where the instructor will take a photo of the group to promote their business of instructing and helping students. So should that person be getting a release from everyone?
I think that you typically would enter into a release in that situation. Your students, to the extent that you want to use their work or reproduce pictures of your students, I would want to see a release in that instance. And
Now,
it's
okay,
so I guess there's an opportunity that none of this will ever pop up. You're kind of preparing for the 1% time that it does pop up.
Right.
And so there's so many places that don't do any of this and put it into line. But all it takes is for that one time for you to receive a takedown notice that says, give us $5,000 and take it down now. Otherwise, we're going to sue you. And then everything, kind of falls down by the wayside, and you realize that you have these protections in place.
Okay, so we have two more questions. If you use strips of paper to create a copy of a painting, is that copyright infringement? Well,
So is this the instance where I'm just trying to picture it in my head, and I'm going to keep using the most famous painting to do it. You're taking
This
maybe
would be a collage.
Yeah,
This would be
magazine photos
collage.
to recreate the
Would just be
Mona
strips
Lisa.
of paper, like to create, say, the Mona Lisa, but
right, exactly.
not painting it.
Yeah, so that may fall under an area of fair use. I'm gonna have to look back at the fair use rules to see exactly what that would fall under. Maybe it would be considered transformative because it's technically a new medium. However, I'd be hesitant to tell you yes or no right this second. It would be something I would have to research a little bit more.
okay. Last question. Back to the poetry question. If you organize an exhibit of artwork inspired by other people's poems, could you display those poems alongside the work as long as you give credit to the poet?
So there is another form of copyright that you can register, and that copyright is compilations, which are carefully selected poems to create, or pictures, whatever the case may be, whatever the copyright is, that you can build into your own selected book. And what you receive is a copyright over that specific selection process, right? So it may be possible for you to do so and also credit them. I'd be wary about trying to see if you can. I would like to see if you could try to get permission to reproduce those if you plan on monetizing them, because that's where the big issue would ultimately.
Okay, well, you did a great job. I mean, I feel like we really put you to the test here with all of our questions.
Good questions. I enjoy them.
Thank you very much.
I have one more question.
Sure.
I have one more question. So, is there a limit to the copyright? Like, if the painter, if the, say Van Gogh or something is dead, is his copyright, is it done over?
Oh, no. All right. Van Gogh's copyright is probably done by now. There is time limits on what your copyright is. If you created something today, what that ends up being is for your life and then for 70 years thereafter, right? Which that's where we kind of get into the estate planning piece, which could be a whole nother conversation. But there's a way to make sure that your copyrights are protected for the 70 years following your life, so your children could potentially benefit off of the copyright that you hold, right? And then whether that's put in trust or whether you leave it to them by will, or maybe an LLC is established and the copyright is assigned to the LLC. There's a lot of different, very cool, unique ways in which you can try to extend the life of your copyright. And that's just, I'm just speaking to the individual that's creating that piece of artwork. If there's two individuals speaking to the artwork, it's going to be for the life of the later of the two artists to pass away. Or if you're going to be doing this as a work made for hire, which is you're like an independent contractor providing a copyright on behalf of somebody else, that individual or company that you perform that work for is going to have that copyright in place for 100 years. So there's a lot of different ways to approach it from there, and that's just all great estate planning stuff.
Okay.
So much.
Yeah, no
Yes.
problem.
Can I just, before we say thank you so much and sign off, just please remember next demo and talk is in June with Jean Potter. And also please join us and volunteer. Please reach out to us when you have some time and join the forces of the Madison Art Society. And Bernie, do you want to remind people how they can reach you?
Sure. Right at the bottom here, btk3law.com is my website. You can email me, bernard@btk3law.com, or you can reach out to me by phone, 203-889-5346. And I'm happy to just talk about this stuff. Again, any way that I can help a creative is a good day for me.
Awesome. We're lucky to have you. Thank you.
Thank you. Have a good rest of your day.
Thank you.
Bye, everybody.
Hi.
Bye. Thanks for joining us.
Thank you all so much.
Bye, Bernie.
Bye.
Yeah.